right? Or have you all had subsequent discussions?
No, Your Honor, I think your idea is correct. So the HANA only had two minor revisions that were two questions that Terrible Herbst originally had revisions to. So my suggestion would be that we go off the Terrible Herbst red line draft.
Right, because they're 23. They're the first question.
Yes, and we address each of their redlined questions, and then I think that should subsume the HANA ones as well, and that'll be the quickest, most efficient way to go through it.
Okay. First thing is, I noticed, and one of the reasons why I asked you about those dark days, because I saw somebody put 4 to 5 weeks on the front of this, the jury. So I needed to start at the loop.
Your Honor, Joel Odou on behalf of the real water entities. Obviously, motions in limine and this court's rulings are going to affect the length of trial. But I don't disagree with 4 to 5 weeks upon further reflection, considering the issues that will have to be presented. In other words, in talking to plaintiff's counsel, it sounds like there's going to be a full presentation of liability as far as Terrible Herbst goes. That would significantly prolong the length of trial to 4 or 5 weeks. Now, certainly I don't want to speak for them. It's their case. But we did not have that issue in Gallagher. And what did we get done in Gallagher? 3.5 to 4 weeks? So I would just note that.
Should I be, this court never reads between the lines. I don't have a crystal ball, but when you say Terrible Herbst is putting on a full presentation of liability.
We'll put on a full presentation of liability for witnesses that they would need to call.
Does that imply that they would not be putting on a full presentation for liability for all the other parties? Or you're saying that's
It's different liability for the meter defendants, Your Honor. It's a completely different case for the meter defendants as it is for real water and distributors or retailers.
okay? Where I'm going with this is you all knew your case, right?
Yes.
And it supposedly was only getting smaller and smaller as you lost certain retailers and distributors.
Not yet, Your Honor. That's my point.
That's what the representatives of the court, if you recall. Wait, remember? Somebody's sitting in a chair that they're not, okay? So I know what you all tell me in court, plus common sense. But that's why confirming the time, as recent as representations from last week, I don't see how 2 weeks gets added in the last week when you've lost one more party. That being, right, so everyone's full cases where everyone's full cases. So I just need a realistic amount of time so we can move forward and get you, and we're accurate to the jurors, right? So what you don't end up happening is you said X, then they have something different, but at the same time, you don't want to lose half your pool if you're going to be putting a much longer time if somebody feels that that might impact who your potential jurors are, right? So we've got to be as realistic as we can. So
Joel Odou for real water. It was just upon further reflection upon some of the rulings that we have received and some of the rulings that have yet to come down. I think 4 to 5 weeks is a better estimate. But again, we have to, on the defense, our case doesn't start until the plaintiffs is concluded. And so I just want to alert the court that it seems like currently, as this case is framed, 4 to 5 weeks seems like a better estimate to real water.
you understand that's different than what I just heard 15 minutes ago when we were talking about your forward year. I mean, I'm hearing what you're saying. It's just, are we doing full liability on everyone? All 5 plaintiffs, all parties who are left in this case? I need to group, right?
So, Your Honor, a lot of the determinations on what happens before this jury will be decided in the motion in limine practice and the motions for summary judgment, and that's what Mr. Odou
Right.
was
Same
alluding
with
to.
any case. Because
Absolutely.
if people get out with motions for summary judgment, then they no longer exist, so it's shorter, right? I get it.
So, Your Honor, again, Teddy Parker on behalf of plaintiffs, for the record, Your Honor. I just added up the hours in terms of the voir dire process. You're looking at 1 full week virtually. And so certainly I assume that Mr. Odou is also considering now a week's worth of voir dire and then starting the trial. I will venture to say, Your Honor, today's ruling may have been a surprise in part to Real Water because the only person who made an opposition on behalf of Real Water today was someone who's been retained by AIG Insurance Company on one of the plaintiffs and not the others. Mr. Odou did not argue that motion, and the court probably will see this play out more as the pretrial motions come. But I understand Mr. Odou's position.
And you realize, presented to this court, the pleadings say Affinity Lifestyle, DBA Real Water. It doesn't focus on who and which firm, right? They're all listed there in the caption.
That's right.
The court's fully appreciative of other statements that have made in court by various people at various times as to whether there may be future agreements. I'm also appreciative that underlying clients may have different views on different days and different minutes, okay? Practice
right.
private practice for a number of years before being on the bench, okay? Sometimes it can be as quickly as picking up the phone and hanging it up, and then guess what? Before you make your next call, it might be a different view. I get all of that. For you all's sake, I just want you to have a nice questionnaire that's accurate, that's really going to help you get moving your case forward. That's really, so if you think it's 4 to 5 weeks, but I also need some clarity, because remember, I then will be telling other cases on my docket, right? Giving them a heads up for the stack that maybe let's evaluate different things, trying to be fair to all the cases on my docket, right? Other ones that a number of cases are on that January stack. It's a pretty popular stack in some respects, but people may not want to be working the holidays and at least would want a heads up that this case is going through X, right? Or if they're trying to go in a February stack. Remember, business court, all the different priorities. I don't want to grant a preferential to start on a particular date because that interferes with your case. All these factors this court needs to take into account, plus many others that I'm not going to go through, to ensure that everyone gets their adequate amount of time. So it makes the most sense to get this figured out now so we can get you a jury questionnaire with the appropriate time frame to get you the jurors that you need and allows your case to move forward fairly accurately and to be fully developed, just like every other case on the docket. So is it 4 to 5 weeks, folks?
I would say 4 to 5. We have the 3 days that are going to be dark, Your Honor. And yes, that's the safest route.
Okay. I've heard that from Real Water. I've heard that from Mr. Pepperman. Do you concur? When I ask plaintiffs, I'm presuming if one of the two of you are standing, you're speaking on behalf of everyone unless the next person stands up and says have a different position. Is that a fair
Yes,
thing to do?
That is a fair thing to do, yes.
Then each time asking Mr. Parker is the same thing. Mr. Pepperman is the same thing as Mr. Parker. Okay. So, Hannah, Milwaukee. Hannah, 4 to 5 weeks?
Ted Fears on behalf of Hannah, yes.
Okay. Milwaukee.
Elizabeth Lowell on behalf of Milwaukee. We concur with Joel Odou, 4 to 5 weeks.
Real Water of Tennessee. I think this is what you were heading to a few moments ago before Mr. Odou. Go ahead.
I concur with Mr. Odou as well.
Okay. ETT1, Terrible Herbst, 4 to 5 weeks or something different?
This is Jan Tomasik for Terrible Herbst. We concur.
Okay, so now I got to do some more math because now we got to block out some more time and figure because now it overlaps to my February stack. I got to figure that one out. Okay. Okie dokie. Trying to get you off the first page. Okay. So, since I did not see any changes on the first page, what this court's understanding is these are everyone's agreed to recommended language, subject to if the court has to tweak something. Is that correct?
Yes, Your Honor. The only objections in the jury instruction and the jury questionnaire are the red lines
Starting at 23?
starting at 23.
Okay. There we're good. So you just know that you need to cross out. I'm not going to go every place you need to cross out because, like, there's Costco in the middle of this. There's other parties on the front page. Someone's going to go through and cross out, like Whole Foods is listed on the front page.
Yes, Your Honor. We'll make sure it's updated to reflect the parties who are still in the action.
Okay.
Your Honor, have you heard from him?
I was anticipating you might in light of a certain paragraph, but go ahead, counsel.
Well, that's maybe the same paragraph. So,
Put your name on the record.
Jim Cavanaugh for Real Water of
Thank
Tennessee.
you.
Thank you, Mr. Parker, for reminding me. There have been recent motions made, and there another commitment, one couldn't be here. A couple of the defendants are now strictly cross-claimants and/or third-party plaintiffs. So two things. United Natural Foods West is now either just a cross-claimant and a third-party plaintiff, as well as formerly a defendant.
About a beverage.
Nevada Beverage, who is now just currently, I
Correct.
believe we're going to have a dismissal, but currently they are a third-party plaintiff and maybe a cross-claimant as well. Again, I understand Nevada Beverage may be dismissing all their claims, but for right now, shouldn't the court make those changes to the designation for those two defendants who are now have just the residual status of their third-party and cross-claims?
The court's intention, the reason why I stated, will someone correct this and fix it right, is that you all are more from, you all have the procedural posture. Right now, it only has plaintiffs and defendants. Yes, the court was presuming you were going to stand up with the third-party defendant concept, right? Because it only says plaintiffs and defendants. So that's why this court was just kind of going for the generic instead of walking through so-and-so's and this, because I realize you all are in the midst of a lot of different probably discussions. So my easy fix was just to say, somebody's going to take the weathering oar to ensure that the front page is accurate as to the parties of this case. Does that meet your needs?
Well, it does until we get to the other parts of the descriptions on page 6 and 7.
I'm not on page 6 yet. I'm on page 1. That's what I'm saying.
I just want to change the party status to correctly reflect what they are.
Right, which is why I was saying as long as somebody's taking the weathering or circulates it among all you all. But this court needs to evaluate and rule on any objections. The court has to ensure it's accurate as an additional. Realistically, I could say something today. You all have a lot of things maybe going on in the background that may not be the same by the end of the day. So I just was going to ensure that somebody was being tasked with taking the weathering oar to ensure whatever gets sent to jury services on the date it's due, and you have it in the communication everyone was e-served with, right? That accurately reflects each of the parties in their position as of when it's being sent off for copying to get to jury services. That way, it's in you all's control, okay? And I actually have to step it back one step. It's actually not that. It's when it gets sent to me to sign. The first page is what I meant to say, right? Because I don't do electronic signatures. I do a regular signature. No, I can do it either way. But anyway, when it gets sent to me to put my name on it, it needs to be as up-to-date and accurate as that. And instead of this court having to call you back in all the time and saying, what's the updated? It just seemed to me we've done in the past. It's been pretty easy. Somebody takes the weathering oar before it gets submitted to me. They show some proof that they've circulated to everyone, that it's been signed off, that the court can sign the first page and it's ready to go to jury services. And then I let you all as professionals take care of that. Does that meet your needs, Mr. Cavanaugh?
It does. I think Mr. Pepperman is going to handle
I'm
that.
about to go to him, but I wanted to make sure I'd finished addressing your issues before
Yes,
I
Your Honor.
moved on. Okay, Mr. Pepperman, go ahead, please.
I was just going to volunteer to take the laboring oar. There's no objection to including parties in here who may ultimately not be at the trial because of future developments. So we'll send it around. If there's a question and someone thinks that a party should be included and the attorneys, I don't believe there's any harm in saying, do you know these people, or is there any conflicts with these attorneys? And if we're all in agreement, I'll remove it. If we're not in agreement, we'll include them in the final form that's submitted, and that goes out. So
Right. Which, as you know, in the past, the court just, whoever's sending it to me for my signature has a representation that's been circulated to everyone. Everyone's on board that this is the version to be sent to jury services. The court can sign it, and then you take whoever's doing the weathering oar to get it copied and sent to jury services, okay? That's the general game plan, because it's usually the most efficient, allows you all to do what you need to do without having to keep coming back to court to say, Judge, here's a quick change. As long as nobody's substantively changing a question, no, fixing a typo's not what I'm talking about, but substantively changing a question, then the court's okay with that. Does that work for counsels for plaintiff?
It does, Your Honor.
Does that work for counsels for real water Affinity Lifestyles, Gold Coast, everyone you represent in co-counsel capacity, Mr. Odou.
Yes, Your Honor, it does. Thank you.
Okay, for Real Water Tennessee, does that meet your needs, Mr. Cavanaugh?
Yes, Your Honor, it does.
And Instruments, that meet your needs, Mr. Fierce?
Yes, it does.
Ms. Lowell, does that meet your needs on behalf of Milwaukee Instruments?
Yes, Your Honor.
Okay, remotely, wait, where'd you go? Tomasik, on behalf of ETT1, DBA Terrible Herbst, counsel, does that meet your needs?
Thank you, Judge. We're in agreement. This is Jan Tomasik for Terrible Herbst.
Appreciate it, thank you. Okay, we can move off the first, and I'm saying that consistently throughout. Like I said, there's some Costco's and other things. I'm not gonna go through those. I'm gonna do what we discussed. I'm gonna really start with page 23, then I'll finish those couple red lines, and I'll give you each a chance if there's something that got missed or that's happened in the intervening that you need me to circle back, okay? That way we can just be, everyone can have their papers in front of them. Okay, so 23. 23, I see that has been suggested to be deleted by Herbst ETT. I will tell you the court's inclination is to keep it in. In fact, as you know, there's specific case law that talks about insurance company bias. Now, here, I would modify this question in a slight bit, okay? And I have two alternatives for potential modifications. The first one would be just having the yes/no rather than answering the yes answer completely, okay? Because then that would be a follow-up question for purposes of voir dire. And oftentimes that's the kind of question that realistically what you might have, whoever's not muted, can you just make sure you're muted just so we get you a nice clear record? Would appreciate it, thank you. Is also, some people view this as even owning a stock through a 401k plan. That can really get you a lot, which technically the question does ask that, okay? Financial interest, it's an indirect financial interest, right? I'm not sure how many of you all know exactly everything that's purchased through a 401k and mutual funds, okay? But it does go there. So generally, this court has found just a yes or no, and then that allows for follow-up because it's not the type of question that in and of itself generally is more through informal discussions with attorneys, isn't something that someone's going to stip to excuse someone on a jury questionnaire, right? It's usually information for follow-up. So that's option one. Option two, from a modification perspective, if it wanted to be modified, is you'd have to modify the first question to make it like, to significant extent and explain that you're not talking about mutual funds, et cetera, right? I mean, some significant that is going to impact your ability as a juror. You have to add some language like that. So those are couple proposed. I get the concept. The court's fine with any of those, or if there's a third alternative. So that was an inclination. Terrible Herbst, since it's your suggested modification, why don't you say why you want it completely out, or if you want one of the court's alternatives, or if you have a third alternative, then I'll circle around to others.
Jan Tomasik for Terrible Herbst. Judge, we didn't see this question as very relevant as there's no insurer as a party in the action, but we will agree to modify it as the court suggested, as to a yes or no.
Okay, so that was your option. Like I said, there's a variety of different options. And the reason why, well, part of the reasoning is even though there's not an insurance company directly, it's the same that happens in automobile accidents and everything else, is that you have several people who usually have some position or somebody might care if one of the major insurers, right, if pick your favorite family member, right, is a high-level executive. So anyway, okay, I've circled to you, counsels for plaintiff. Since you wanted it in the first place, what's your thoughts?
Your Honor, we're fine with the modification the court suggested.
Which of the two? I gave you a couple.
Exactly. So let me give you the pros and cons. If we go with just the yes or the no, then that means we got a lengthier voir dire on that question potentially. If we go with the explanation up front and give the caveat that if it's a 1% ownership in a mutual fund, something like that, then we probably wouldn't have to follow up, but then it's a follow-up question. So we're fine either way, is my point. One leads to longer voir dire, the other one leads to more lengthy involvement in terms of the veneer person filling it out.
So let me circle around what other people's thoughts are, because then where I'm heading is kind of let's hear what everybody else's thoughts are. Counsel for Real Water,
Nothing to add, Your Honor.
Hannah,
Nothing to add, Your Honor.
Milwaukee.
Either option, either modification.
You know what, Mike? Guess what I forgot to do? Name and client that you represent, even though I've been
Joel Odou
trying
on
real.
behalf of Real Water, nothing to add, Your Honor.
Chad Fears on behalf of Hannah, nothing to add.
Elizabeth Lowell on behalf of Milwaukee, we have nothing to add.
Yeah. And you understand why we have to keep
I do.
because it's
We do.
you all's transcript that you're going to want. I mean, okay, Mr. Cavanaugh on behalf of Real Water of Tennessee.
And Kavanaugh for Real Water of Tennessee, I would agree with ETT one's, your first option, yes or no, I think is sufficient.
Okay, so what I have is 2 yes or no's and 1 either option, and then the other some no voices and either option. So we'll just leave it at yes or no and leave it as experienced counsel if you think you need some follow up. Okay, that takes care of 23. So it doesn't change your numbering. The next one I showed was 49. Is that correct?
Oh, I'm sorry, 24.
Oh, I'm sorry. Yes, right there on the back page. Okay. Court's inclination on this one is insert the word immediate and put a time limitation, like within the last 4 years, 5 years, or your relevant time period from this case. So that's the court's inclination, to keep in the concept for the same reasons that, the insurance company with the potential bias with allow you to make a well-reasoned, which are the 2 purposes for voir dire questions, regardless if they're in a jury questionnaire or if they're verbally in voir dire. But like I said, add immediate family members, so you're kind of clarifying what you really need, and then some time limitation so people don't feel as if they have to go back 20 years, right? And that's 20 years as a hypothetical. Counsel for Terrible Herbst, you heard the court's inclination. Go ahead, please.
Jan Tomasik for Terrible Herbst. Judge, number 24, if we do what the court just proposed, it's exactly the same as what is sought in number 21. And it goes towards whether you or your spouse or immediate family and listing the job titles that have been worked in for the past 10 years. So presumably, I think it's just redundant. And also, it's too broad as currently written. If it went towards claims or adjusting, then maybe we'd have a different position. But the way it's worded, it's too broad, and I think that 21 already takes care of this number, frankly.
Isn't 21 limited to spouse or partner, and isn't 24 family members? So that would include brothers, sisters, siblings is really where the court was going from immediate. Is it kind of...
That is correct, Your Honor. Teddy Parker on behalf of the plaintiffs. 21 says specifically former spouse or partner, whereas the other is broader and says family.
Okay. So your thoughts on 24? Obviously, you'd like it in as is, but...
As is, Your Honor. I think that the court suggesting immediate family members is fine. That way, I guess we rule out distant cousins, and I think that's fine, Your Honor.
have the limitation as to a time frame.
Your Honor, I
21
would...
does have 10 years. This one doesn't. This one is...
Yeah, I would think we'd keep it the same, Your Honor.
What would be a reason? I mean, what information could you gather hypothetically if somebody's great-grandfather, happened to work for insurance company X at the turn of the century?
Well, yeah, Your Honor, that's...
I mean, Warren Buffett and, are kind of on the,
Your Honor, you suggested, I think, four years.
I said 10, up to 10 years. I said not.
But 10 years is fine, is what I thought.
Okay.
Your Honor, Joel Odou for Real Water. We prefer the question stay as it is. If somebody worked 20 years ago for an insurance company, maybe we don't care. If somebody worked 20 years ago as an insurance company adjuster in the field of pharmaceutical claims or toxic tort, perhaps we do care. So I would prefer, or Real Water rather, would prefer to leave the question as it is.
How about adding the word immediate before the word family members?
Again, we don't have a problem with the way the question is currently phrased, so we would leave it exactly as it is.
Okay. Breaking it up. Real Water of Tennessee.
Your Honor, I would concur with Mr. Odou on this.
Milwaukee.
Your Honor, we have no objection to the court's proposed modifications inserting immediate and a time limit.
Anna.
Chad Fears on behalf of Hannah. We are fine with the court's insertion of immediate and agnostic on including the last 10 years.
Okay, well, we're gonna add the word immediate. I'm not gonna put in the 10-year limitation. I think it was a well-reasoned decision that realistically, yes, if somebody was specific to the area, and since you've only given a couple of lines here, if they wanna go back, then they've done it. And immediate limits it in one respect, where it really is not only parallel to the other questions, but it also gets a sense in fairness, because I have to balance the interest of our prospective jury members and how much time they're being asked to complete these questionnaires. Because remember, when they come in to complete the questionnaires, they are not being compensated. So even under the new statute. So now is the next one 43, is that the next one, counsels?
Your Honor, on question 24, just to confirm, we're adding the word immediate behind family member, and then everything else stays the same.
Yes, I'm listening to everyone's discussions, and given the balancing of the needs between members of the jury, taking into account the purpose of voir dire questions, whether they're written or verbal, is it would allow for bias, as Mr. Duke points, from either side. It's not weighted one way or the other, because each side might have a viewpoint of what somebody was doing. It gives you the information that is necessary, and by doing immediate, limiting it to a similar grouping that's been asked in other questions, which I will tell you, the courts generally, I see all the questions say immediate family member, but since you all didn't object, I'm going to posit it out there. Is there any reason why certain of the questions say immediate and certain of the questions do not? Or is that maybe just a matter of the source of where you picked up the potential question?
I think
This is balancing the needs of our prospective jury panel questions, why I'm asking.
I think it's a combination. It is largely a source. We've used a similar questionnaire before in other cases, but I think there are some questions that we want to be broader than immediate family members, just because it could affect potential biases of the jurors. So I guess both is the answer to your question, Your Honor.
Okay, so
Your Honor, the next one we see is on page 19.
page
Again,
43, right?
Well, it looks like it's
The numbers are off on
off.
the,
Yeah, it says
Oh, I'm sorry.
51 on ours.
The loved one?
yes.
Yes, that's the one,
Okay.
Your Honor.
It's crossed out as a 43, so I was going on that number because that would have been paralleling it from plaintiff's original. So
That makes sense, Your Honor.
43 / I'll read it. If you or a loved one were injured or killed through alleged fault of another person or company, would you consider filing a lawsuit? And then it says, if no, why not? Here's the court's inclination. Well, the court's concern with the if no, why not is it's not a balanced response. It's only asking your potential juror one side of the coin versus the other side of the coin. But let me hear from Terrible Herbst, because it's their objection. Go ahead, please. You want it out completely. Yeah. Go ahead.
Jan Tomasik for Terrible Herbst. Judge, we also reached out to plaintiff's counsel on 11-8, and this was one of the modifications we posed, was that it can be a yes or no.
Okay, so you'd be fine if it was modified to be yes or no? So the
Yes.
prospective juror would have an option, and what you may wish to do, oftentimes when this one comes up, usually there's a parenthetical where they put optional for the reason, because, well, sometimes people may have some personal details that they may not wish to be fully disclosing, and sometimes they've had traumatic events in their lives that you don't necessarily want in writing under Stevens Media, which currently could be open to the public. So sometimes we utilize the term optional with these kind of answers because it gives a comfort level for your potential jurors. But once again, I hear what counsel want to say before I make a determination. So let me hear from the rest of counsels. Counsels for plaintiff, go ahead.
So my understanding is the modification would be the question's the same, yes or no, and then the explanation is why or why not.
That's what I'm understanding.
We're fine with that modification.
Okay. Counsel for Terrible Herbst, was that the modification?
No, Your Honor, and I apologize. Maybe I should have been more clear. The question should be posed as whether you have a belief that would prevent you from filing a lawsuit if a loved one was injured or killed.
Wait, so you want to add if you have a belief?
Well, that's what it should go, is it's whether it's an unqualified belief that would preclude them from filing a lawsuit.
Can you explain that a little bit more? I'm a little concerned that you might be broaching on some
Right. So
religious aspects that, let me hear what your reasoning is, please.
okay, so the proposed amendment would be if a loved one was injured or killed through the fault of another person or company, do you have any beliefs that would prevent you from filing a lawsuit? And the only two options would be yes or no.
So are you trying to get the concept about whether or not certain people have a strongly held belief that they can't judge other people, and that's why they wouldn't file a lawsuit? I'm trying to get to the legal basis on a jury questionnaire, right? Or a voir dire question.
Yeah, so I mean, unless it's a yes or no response, I mean, if they answer yes, then they would be precluded, obviously, and then no, they can be subject to go forward, right? So the explanation of why, like Your Honor said, is touching on personal aspects of the potential juror that are unnecessary.
I just was trying to get a better understanding because I heard your modification is changing the question from the concept of what it might be trying to gather. From counsel for Terrible Herbst, do you wish to set forth your position, or does it?
Your Honor, we were inclined to go with his first suggestion, the why or why not, or yes or no. But given his last comments, again, Teddy Parker on behalf of the plaintiffs, Your Honor, that didn't make any sense to me. He's inviting jury nullification in the form of the question. It makes no sense, in my opinion. So, Your Honor, I'm fine with a mutual yes or no or why not, something that can be taken on either side of that decision. But a belief structured in this form of question doesn't seem to make sense to me, Your Honor.
Okay, counsel for Real Water.
Joel Odou on behalf of Real Water entities. We would go with the yes or no in the first part, and the second part, why or why not, parentheses, optional.
Okay, Hannah.
That fears on behalf of Hannah. We agree with Real Water's proposal. Just
Real Water of Tennessee.
Well, we would agree with Mr. Odou and Real Water entity.
Milwaukee.
Elizabeth Lowell from Milwaukee, we would also agree with Mr. Odou.
Okay. Well, I have 4 with one suggestion, a 5th that's kind of okay with part of it. And
Your Honor, we have no objection to adding optional.
oh, okay. So that's what we're going to do. Okay. So you're going to add optional and put yes or no, so that way you can get a balanced answer from either side. You're doing it optional, so if somebody has some type of traumatic event or something, they don't feel like they're compelled on a put in writing, subject to the public. We're balancing that need there as well. Okay. The next one, going to page 20, which was 48. Do you have beliefs that would prevent you from returning a verdict? And counsel for Terrible Herbst, this is the one I thought you were trying to get that concept on, but okay, so 40. So it was 47. Do you have beliefs that would prevent you from returning a verdict in excess of $100 million in a product liability case against any of the companies who are parties to this case that were justified by the evidence? And then usually I take these in conjunction with one another because most people argue these. Do you want me to take them in conjunction or one by one? That in the very next
Keep them
one.
together, Your Honor, just for purposes of getting it done quicker. Teddy
Counsel
Parker,
Terrible
Madam
Herbst, you okay
Plaintiffs.
if I do these ones together? Because usually,
Yes, Judge.
okay. Anybody object to me doing them together? You could.
Your Honor, it's Chet Fears on behalf of Hannah. Are you talking about 47 and 49 taken together? Because they both have
47 and
those.
48. Oh, wait, hold on a second.
On the red lines, it says 55 and 56 on ours, Your Honor, but
Okay.
it's the same two.
Well, let's go. Okay. Right. Let me read the question so everyone's clear, okay? It's probably going to be an easier way. What was formerly the 47, but now on the underlying on the version which is the ET&T reads, do you have beliefs that would prevent you from returning a verdict? And the requested redaction is to delete in excess of $100 million in a products liability case against one of the companies who are parties to this case if it were justified by the evidence. 48, which do you have beliefs that would prevent you from returning a verdict of, this one's stricken out, of no damages, then not stricken out, in a products liability case against any of the, and the word companies was stricken out, and it says plaintiffs who are parties in this case if it were justified by the evidence. The court's inclination to keep it in its original form. And the reason why that is because there's a series of cases that say you can't ask for about a specific amount, right? You can't do $100,046.32. However, the general question about whether there's a floor or a ceiling that jurors have is a proper question. How many zeros you put on said floor or ceiling is really not been precluded by any appellate authority ever cited to this court, unless you're aware of something that came down while I was, not even Thursday, so it couldn't have come down yet. But somebody's aware of something that the court should be considering, please let me know. But generally, these are the kind of questions that have been specifically approved in appellate case law. It's really a matter of how many zeros. So I'm inclined to keep them both in because it gives you both concepts. Is there a floor? Is there a ceiling? And when I use the term floor, it means no damages. Counsel for Terrible Herbst, go ahead, please. It was your requested redactions in both of these.
Judge, this is Jan Tomasik for Terrible Herbst. We will withdraw, and based upon what the judge has just mentioned.
Yeah, it was an inclination. Okay, since it's withdrawn, does anyone else want to be heard? Anna, you seem to have a finger up, but go ahead.
Chad Fears on behalf of Hannah. We did object to the in excess of $100 million. I think the proper question, we had the same issue with the question 49, is we just think it should just be simple. Do you have beliefs that prevent you from returning a verdict in a product liability case? You can take out 48 if there's any concern about money. We believe this violates EDCR 7.70. It's setting hypotheticals. We believe that it's conditioning the jury or the veneer for when we have voir dire, and there'll be certain questions that we have dealt with and passed with our esteemed colleagues on the other side that we think cross that line of 7.70.
You may hear our argument on this,
Go
Your
ahead,
Honor.
please. Yeah.
Teddy Parker on behalf of the plaintiffs, Your Honor. We have recent case law that says just the opposite of what Mr. Fears said. I don't know what he's alluding to in terms of 7.70. In my opinion, that runs contradictory to the Supreme Court decisions on this topic and contradictory, I think, 3.4. Supreme Court rule 3. I think it's 3.4, Your Honor, 3.5. But the Supreme Court decision regarding this is on point, and the court's correct, allowing for numbers in excess of 500 million or 2 billion. As long as you're not attempting to get the exact number you're looking for in your special damages and your future damages, it's been allowed, Your Honor. So I think Mr. Fears is completely incorrect.
Okay. So just so we're clear, I'll read EDCR 7.70C, just so everyone's on the literal same page in case you don't have the benefit in front of you. 7.70 is voir dire examination C. Well, let me go back to the captioning right above that. The following areas of inquiry are not properly within the scope of voir dire examination by counsel. And C is questions touching on the verdict a juror would return when based upon hypothetical facts. The reason why the court gave the inclination it gave is because you all know I call it the funnel, right? Top of the funnel is Supreme Courts, pick your favorite Supreme Court, right? And then it goes down, right, to rules. It goes down to the EDCRs. Nothing in the EDCRs can conflict with anything above it, right? So when you have specific case law that does allow questions with regards to verdict amounts, that's why I made the distinction and I put the sense in, right, is that would be a hypothetical to a specific verdict, whereas the other is to go towards bias or inclination and see if there are artificial floors or ceilings. Is usually the generic term that I use because it has the most neutral concept rather, but somebody can't go above something, and there's a case law that says if a juror has indicated that they can't go about something, that realistically the juror potentially should have been excused. So if you want the citations of those cases, I can give them to you, but there's a number of them within the last few years that have come up in that regard, and it's not unusual that I get bench briefs that nicely articulate those on a regular basis. That cites those. So that's why my inclination was, just so you understand it. I appreciate what the EDCR is. Yes, former chairperson of the EDCR, but remember that question is not intended to be contradictory to the case law. It's to go to the specific verdict amount, which is precluded or close thereto. I mean, if there were numbers in each of those, okay, then the court would have to evaluate that. I make no advisory rulings. Counsel, Mr. Pepperman, you wanted to say something. In light of what I just said, do you still want to say something? Go ahead.
No, Your Honor, I agree. I just was going to add that Corey v. Strand is.
Corey v. Strand, yes. Judge Bearkey, yeah. Familiar with that. And the juror was supposed to be excused for doing that, even though then later on said it could be fair and impartial. Anybody else want to be heard? No. Okay, so they're staying in as is. Okay, so now we get to, and by the way, just for your purposes of your record, Hannah, you objected only to 47 in the red line. I did not see that you objected to 48, so I only addressed yours in 47, okay?
That fears on behalf of Hannah, that is correct, Your Honor.
Okay. Okay, so now we're to 49. 49, once again, is a terrible Herbst one. And I'm going to read these just to make it quicker for you all. Do you have any beliefs that would prevent you from returning a verdict in excess of $1 billion for punitive or exemplary damages against any of the companies who participate in this case if it were justified by the evidence? Counsel for terrible Herbst, let me hear your position. I'm not going to give an inclination here. Let me hear them, please.
Judge, it was Jan Tomasik for terrible Herbst. It was a similar reasoning to before. On this one, we came up with the proposed amendment that we would strike the language going towards companies who are parties in this action and changing it to a straight proposed amendment of, do you have beliefs that would prevent you from returning a verdict in excess of $1 billion for punitive or exemplary damages in a case justified by the evidence? That was our proposed amendment based on Corey C. Strand and Jitnan preceding that case.
Jitnan versus Oliver. Okay. Counsel for plaintiffs, were you the ones who didn't want the proposed alternative? So let me explain to the court.
Your Honor, we
why.
believe they should be kept. Again, Teddy Park on behalf of the plaintiffs, Your Honor, we thought they should remain the way they are. Jitnan did not address this issue. Jitnan dealt with expressing unequivocal the ability to remain unbiased or
Fair and impartial.
Yeah, it had nothing to do with monetary amounts, Your Honor. I think I've read every case the Supreme Court has put out on the process of voir dire selection, the jury selection process, Your Honor. And this questionnaire has been used, and these questions have been used, not to say that's an indication that they're okay, but I would suggest to you, Your Honor, that there's no difference in terms of his argument for punitive damages as it is for compensatory damages, Your Honor. And we're not going to tie our direct number to the hypothetical that we're putting in the questionnaire, but we need to be able to know whether or not fundamentally or from an ideology standpoint, a juror can award punitive damages that send a deterrent message, especially given the size of the industries involved in this case.
Okay. Let me circle. I did not see that. I would dash by yours. So hand instruments, you deleted in excess of $1 billion in your proposal. So do you want to be heard?
Yes, Your Honor. Shed fears on behalf of Hannah was the same reasoning of conditioning. I think you've already made that ruling on the previous. So I just, for the record.
Okay. In some previous cases, what has been a modification to this is adding to, in the end of it, instead of saying the evidence, we're saying by the evidentiary standard. So that's making it clear that it's not the same evidentiary standard as it is for underlying compensatory damages, since punitive damages is by clear and convincing. So I'm inclined to do that because I'm inclined that the document itself that's provided to the jury, if it ever comes up, is that words matter. And if words are going to matter, and well, we all know there's a different standard between punitive damages and whatever. The concept of what number you fill in is the floor and ceiling concept. The challenge that's come up sometimes with this is the fact that it seems to imply, or could be viewed to imply, that's not a ruling, but it's been raised to this court, that it could be viewed to imply that it's the same standard for compensatory damages as it is for punitive damages. And other people have said that no way does a juror think about that when they then hear the jury instructions a couple months after they filled it out. So I've heard it from all different sides, but one proactive manner to eliminate that issue is sometimes using the word is justified by the evidentiary standard instead of just using the word evidence. Does anyone have any thoughts on that? Because that was not a proposal that came from any party. I just give you that as something that we've addressed in the past. If anybody has any thoughts of that. First off, counsel for terrible Herbst, would that address your concern, or what's your thoughts, even if it doesn't address your concern?
Jan Tomasik for terrible Herbst. Yes, Judge, we agree with that suggestion.
Okay, but does it fully address your other concern, or do you still object? I just need for your clarity of record, folks, right? You're asking me to rule on these, so I'm trying to make sure that you're clearly telling me what position you have.
Yes, to the extent that suggestion would be agreeable to us. We also believe that the verbiage as to companies who are parties in this case should be taken out.
Okay. So counsels for plaintiffs, your thoughts?
Teddy Parker on behalf of the plaintiffs, Your Honor. I'm assuming you're suggesting that that language be added to both dealing punitive damages, 0 or
Correct.
100 million. Your Honor, I guess we could deal with it during voir dire, but I think what's going to happen, potentially that will raise another line of questioning during the voir dire process. I'll just prepare the court for that, because then they may ask the difference in evidentiary standards. They may or may not. They may forget that they even prepared this questionnaire, the answers to this questionnaire, specifically this question. But
So-
I can see that coming.
So for clarity of what I know I'm ruling on, the first part was the objection from terrible Herbst, right? So I have to rule on that. The other was just a question from the court. If everybody says they do not want the terms evidentiary standard, civil evidence, then you all can say that, and I won't change it. If somebody suggests that we should have evidentiary standard, then I'm going to evaluate that.
I think it works the way it is, Your Honor. I'm only suggesting to the court, since I don't know if we're going to do any type of pre-instruction to this panel or this jury, that this could lend itself to a longer process on these these questions, Your Honor. I just can foresee that coming.
So you object to any modification at all to the one proposed by plaintiffs? I just for clarity, I need to know what I'm ruling on, please.
Yes, Your Honor. I think it should just remain the same,
Okay.
Your Honor. If it's a change, Mr. Parker, or we don't have it, then my fallback position is I think we just need to consider how, just know going forward that this will lend itself to a greater time spent on voir dire.
I think it minimizes voir dire, actually.
I would hope, Your Honor. I just think that the questions in terms of the differing standards, the clear and convincing versus the preponderance of the evidence, may come up because of those.
But it's not putting in clear and convincing. It's just putting is justified by the evidentiary standard instead of the word by the evidence. It's just replacing the word evidence with evidentiary standard. Just to show that there is a different evidentiary standard, particularly since it's a bifurcated case if you get to punitive damages, right? So
Right.
It's just saying that, look, there's something different here between this series of questions versus something different. So once again, the court's not, bottom line is, I'm not requiring it.
Okay.
I'm going to evaluate it if somebody's going to ask me to evaluate it. When I go through these, I try and, if some things that's happened in the past, give you a caution that sometimes people have raised an issue, so that's a way to fix it. If nobody wants it, then you all are putting on the record that nobody wants it. Then I don't deal with it.
That's fine.
Okay? Mr. Odou.
Your Honor, Joel Odou on behalf of Real Water, we would go with the evidentiary standard, just like the court said.
Okay, is that a request, or is that if it comes from the court, you're okay with it? And sorry, I keep asking you these fine-tuned questions, but I'm just trying to have a better understanding whether people are just
We would request it on behalf of Real Water, Joel Odou.
Milwaukee.
Elizabeth Lowell for Milwaukee, we would concur with Mr. Odou and request.
Anna.
If here's on behalf of Hannah, we would request the addition of the evidentiary standard. We do not have an objection to ETS deletion that they wanted.
Okay, Real Water, Tennessee.
Well, Tennessee will go with Real Water Incorporated and Affinity's suggestion, Your Honor, and request.
So I'm overruling I'm keeping in the numbers. First, I'm keeping in the questions because I think they're appropriate for the same reasons the court gave the prior analysis. I'm keeping in the numbers, which was the requested deletion from Hannah. So I'm overruling Hannah's and their requested specific deletion. I'm overruling Terrible Herbst ETT, or the request, however you want to phrase it, with regards to these questions in their entirety. And the court, at the request of multiple parties, is going to put in evidentiary standard because I think it clearly articulates that realistically it is, since it's a bifurcated proceeding and it is a different standard, it highlights that there's something a little bit different here, and it doesn't raise any issues for the jury that would preclude it on a voir dire question, and allows people, if they want to do follow-up, they can do follow-up. So, and I'm no way saying that that means people get to add hours to their estimates, but we'll stay tuned and see what happens there. Okay. I told you all 215. I'm realistically, I got to get through these. Okay, 51 is, do you believe there should be legislative or other legal limits placed on how much money a jury should be allowed to compensate a person for loss of enjoyment of life or for pain and suffering? And so for 51, go ahead, Terrible Herbst.
Your Honor, if I can, the two legislative cap questions are essentially the same. One's compensatory, one's punitive. So I don't know if it's quicker to handle.
Sure, I can handle them the same thing. Legislative caps, except for one specifically does have it, and one doesn't, but okay.
Jan Tomasik for Terrible Herbst. We object to these questions. We think both of them should be taken out. Even though a potential juror may answer yes, he may still be qualified. Okay.
I was going to tell you the reason why the court was treating these a little different, right, is because there is a provision, right, on the amount of punitive damages, right, tied to wealth of companies, tied to the amount of verdicts, right, et cetera. So there actually is a distinction. This is I have no med mal component, so I don't have that issue here, but so I view them a little bit differently. But go ahead, counsel for plaintiffs, your thoughts, because you want them as is.
We do, Your Honor. The legislative limits, there is one, of course, on medical malpractice cases. There are certain limits. There are no limits when it comes to product case. There's no limit when it comes to like insurance bad faith case. So there are some places where there are no legislative limits on those.
But you've got to breach a warranty.
Yes, on a product case. No limit. So I could see that when the court was speaking, I could see the wheels turning. But yes, on a products case, there is none. But that doesn't mean, in terms of the bias, we shouldn't ferret that out. Right. And that's what I think ETT was going to.
Doesn't that get me back to the UC's, a statutory argument that was raised by Milwaukee? I'm not going back there.
I know you're not.
But don't you all have a difference of view of how that particular claim is presented in this particular case, in which is subject to future motion practice? So, of course, the court gives no advisory rulings and not saying anything more on the nature. It's just the fact that there might be a difference of opinion is the way I'm phrasing it for today's purposes.
No, we don't believe there's any difference in terms of this question and the impact.
Okay.
We think we're fine there. I think these questions are appropriate, Your Honor. These questions are designed to find and ferret out bias in terms of another way of looking at caps and ceilings, Sean.
Okay, Milwaukee, I'll head your way. Not to revisit earlier this morning, but just for this.
Elizabeth Lowell for Milwaukee Instruments, and we are discussing 51 and 52. Right,
legislative limits. Now, I saw Milwaukee didn't object to any of these, but I'm just giving you a moment,
right,
just in case, in fairness to everyone else.
We did not object to them, and I don't know what ETT's proposed amendment was. ETT asking for them to be removed?
Yeah, so you have to realize the red lines I received did not show any alternatives, so I have to treat them as straight deletions. That's the reason why I keep asking the question, because it's not like somebody gave me an alternative. So since you didn't object, should I just move on?
Yes, Your Honor.
Okay, that's a question. It was a legitimate question, but Hannah Instruments, I didn't see you objected. Did not, so.
We did not, but I mean, this is a UCC. This Chad Fears on behalf of Hannah. If this is a breach of implied warranty in UCC, there seems to be a little different than just a product. Because I agree, products don't have the cap. But a claim, typically, Your Honor, this is not, we haven't briefed it. This is going off memory. The remedy is usually the buying back of the product. They may have a different approach. So that's why I just raised that. I think it is different.
Remember, the court's not taking any position of the nature of this, but I'm just trying to hear people's, okay, but you didn't object either, right? Real Water of Tennessee, do you want to be heard?
Your Honor, Jim Cavanaugh from Real Water of Tennessee. I would agree with and join ETT1's request to delete these two.
And counsel, Real Water entities not of Real Water of Tennessee.
Your Honor, Joel Odou on behalf of the Real Water Inc. Et al. Entities, we would prefer to keep the question.
Both of them, both 51 and 52?
Yes,
First
sir.
one on loss of enjoyment and pain and suffering, yeah. Okay, here's what the court's going to do. 51, do you think there should be legislative or legal limits placed on how much money a jury should be allowed to compensate a person for loss of enjoyment of life or for pain and suffering? Well, that one actually is subject to case law. You can't, okay? It's not. So it's a proper question, because if somebody has it, there's some case law that says not. 52 is a little bit more challenging because depending on how one claim against one entity, potentially, I'm not making any ruling which way it is, there seems to be a dispute on how that's being tried in this case. But realistically, in rereading the question after listening to everyone, it really is just asking their opinion if there should be. It's not saying contrary to the law.
Exactly.
So it's, if somebody's thinking something should be the law, then that's really getting their thoughts and beliefs. And so I'm leaving both of those in as is. So the extent that overrules part of ETT1 DBA terrible Herbst, but is a concurrence with others, it is what it is. Okay, so
Our next one we show, Your Honors, on page 23.
the old 67 or the current 67. Some folks believe someone is killed
That's the
or
one,
hurt.
Your Honor.
Okay.
Perfect.
So page 23, some folks believe when someone is killed or hurt, usually it's due to fate or destiny, God's will, or just plain luck. So it's wrong to sue anyone because that's not going to happen. It's bound to happen. Counsel for terrible Herbst, you objected to this, but I thought this was what you were asking earlier for the one in the 20s because you wanted to know if somebody had a belief. So, counsel, are you still requesting that this be deleted or not?
Judge Jan Tomasik for Terrible Herbst. Yes, we proposed an amendment that this be changed to a yes or no. And the proposed amendment would be, do you have any beliefs, religious or otherwise, that would prevent you from suing anyone, rather than asking whether they completely, somewhat agree, mostly agree, entirely agree. It would just be a yes or no.
Okay. For future reference, please, if you're going to redline and you have alternatives, you got to give them to the court so I can evaluate them in advance, okay? That was the whole purpose. Remember I said redline with alternatives so that I knew what was being presented with. But we're just going with it for today, but that really would be helpful, just FYI, for the future. So what is the disagreement with, I know you prefer to have a yes or no, but since this fleshes out more information rather than less information, can you please enlighten the court what you think would be inappropriate about having these check the boxes?
It's becoming more broad and leading to, opening up the voir dire process to then be lengthier and lengthier rather than shortening it. It should be a yes or no. If the prospective juror responds in the affirmative that a belief would prevent them from suing anyone, then obviously they cannot serve, right? And if we get into the completely agree, somewhat agree, mostly disagree, entirely disagree, it's just broadening and opening the door for later lengthier voir dire.
And counsel, when I read through this one, what came to this court's mind is, that standard line of question, is this a strongly held belief? Is this a belief no matter what I tell you can change? We hear that a lot in the voir dire questioning. And I thought this was an anticipatory question to find out if this was a strongly held belief, which might potentially preclude, I'm not saying it would, but that an argument would be utilized to potentially exclude someone versus if it's a somewhat, that it may not be such a strongly held belief and that they can still listen to the instructions of law. Now, once again, I can't get in people's minds, but this is also not the first jury questionnaire I've done. So I'm hearing what you're saying. Let me hear everybody else's circle around. Counsels for plaintiff.
Your Honor, this is actually a time-saving set of questions. Because quite often, if they're ambivalent about it, then we're not going to waste time trying to figure out if they have feelings so strong that they couldn't follow the law. And so we've used this as a time-saving set of questions, Your Honor. So I think I have the completely opposite position as ET&T's counsel on this question, Your Honor. I think it should remain the same.
Your Honor, I would add too, the rest of these questions like this.
Mr. Pepperman, also on behalf of plaintiff. Go ahead, please.
Thank you, Your Honor. I apologize. The rest of these questions too, the purpose of voir dire is, yes, to identify biases for purposes of challenge, but it's also to allow the parties to exercise their peremptory challenges by choice. And so there are questions in here that are elicit information that may be someone that plaintiffs, for whatever reason, they don't want that type of juror. And same with the other parties, which is, I think, why none of the other parties objected to any of these questions, because we both get this information from them.
I'm just, because remember I told you 2:15, folks, and I'm pushing where I need to, sorry, 2:30. And I want to make sure you have a full opportunity to have these all heard so everyone understands, and we'll get you the appropriate questionnaire. Nobody else objected. Does anyone else need to be heard? I'm seeing negatory nods. Okay. I'm keeping it in because I do find that it goes to the concept of whether it's a strongly held belief. It does provide potential jurors, well, for both the two purposes. One, if there's bias. Two, to exercise well-reasoned peremptory challenges so that it would be appropriate to stay in. With regards to question 68, the court's inclination is the same thing for the same reason. While it's phrased a little bit differently, it still elicits that type of information to go to the breadth and depth of a viewpoint. Counsel for ET&T, I want to make sure that you get heard. Go ahead, please.
Judge, our reasoning for 68 was the same as 67, and if Your Honor has already set forth the reasoning on 67, we will withdraw 68.
Okay, since withdrawn, the court need not rule. Next one I show is 94. 94, the court's, and that's 94 is what should be done about the homeless first. Find work for them or find them a place to live. First off, well, you all may be aware that the choice of words that you used is not the current appropriate terminology, right? It's individuals experiencing homelessness or phrases similar to that. I'm not going to be a wordsmith here, but it's up to you if you want to potentially have your
We'll correct that, Sean.
But my general inclination is to keep this in because it really is setting forth people's positions. I mean, I understand the psychology behind the concept of whether you want people to work or you want to find a solution to them and where that might lead people for the peremptory challenges. This is one that's often argued to me that allows individuals to exercise well-reasoned peremptory challenges because they get a better sense of what's the type of issues that are present in each person's mind as a potential juror. Like I said, the other concept, if you want that word, you do that one at your own risk. But counsel for ETT, Terrible Herbst, your issue on this one, please, on 94. You're the only one that objected.
Yeah, we object to the totality of 94. We don't think it should be included. It lacks relevance, and we'll leave it with that.
Okay. Counsel for plaintiffs.
Your Honor, Teddy Parker, on behalf of the plaintiffs, Your Honor, we will change the language to people experiencing homelessness as opposed to the homeless.
Okay, so why should the court keep it in response to counsel
Your Honor,
for Terrible Herbst?
Your Honor, you hit the nail on the head. This is a question that is typically in at least every jury questionnaire I've been a part of, where it's meant to ferret out people's belief in, do you buy someone a fish or you teach them how to fish? And those questions, of course, ferret out biases of potential jurors.
Okay. Anybody else want to be heard? Nobody else objected? No. Okay. Court's going to rule the objection and keep it in. It's up to you. I leave you all that discretionary aspect if you want to have the current terms with regards to how you address people who are experiencing homelessness. This court will utilize the term, usually individuals experiencing homelessness, those experiencing homelessness. But I'm not requiring you to put that in your jury questionnaire. You all choose if you want.
No, Your Honor, we appreciate the court's suggestion, and we'll modify it.
It's just, okay, next one is the old 100. Do you worry about your own safety or your family's personal safety? The court's inclined to keep that out and sustain the objection by Terrible Herbst, because realistically, I think that raises way too many issues. It's so vague and it's so broad, and realistically, if there's an issue, that is one that gets addressed more in person with a potential juror based on their other responses. It's on page 30, if you're looking for it. Right after do you watch television? So, counsel for ETT, Terrible Herbst, go ahead, yours. You objected? You heard the court's inclination? You can agree, disagree?
Judge, we agree with what Your Honor just said above, and we agree with your inclination. Nothing further.
Counsels for plaintiff?
Well, we prefer that it remains, but we understand and appreciate the court's position. We're not going to spend much time arguing about it, Your Honor.
It opens up potentially. Do
Understood.
you realize the comments you might get on this?
Understood. That's why.
And I'm not precluding it. You realize this is the court's rulings on juror questionnaires. These are no advance rulings on personal voir dire. I will address those when you all submit your proposed voir dire if I have objections then. But this is for a questionnaire, okay? No, did anyone else want to express a viewpoint on this one? Do you worry about your own safety, your family's personal safety? Nobody wishes to? Okay. Court's going to go with its inclination as doubt. Like I said, I take no position for in-person. I really think this is the type of question that usually can be explained better in person. I think it raises too many challenges. I do not think that it goes in the written way with a yes or no. Goes to either the purposes for voir dire at this juncture. It does not really show a bias, and it really doesn't allow you enough information to really make a well-reasoned peremptory challenge, and so that's the reason why the court would exclude it. Okay, so that means you have to renumber after that one, right? Because the rest were just modified a bit or overruled. Those are all the objections I saw to the juror questionnaires. Was there any others? Did the court go over them all? Is there anything else you need on juror questionnaires?
I don't believe so. Your Honor.
Not from plaintiffs, Your Honor.
The water?
Joel Odou on behalf of Real Water, nothing further from us. I do have a clarification question on procedure, but not on jury question.
Okay, let me circle around and make sure I get everyone on this part, then I'll get back to your procedure question. Real Water, Tennessee. Anything else on juror questionnaires?
Nothing else.
Hannah,
I figure somebody have a hand and nothing else. Your Honor.
Milwaukee.
Elizabeth Lowell on behalf of Milwaukee, nothing else, Your Honor.
ETT, Terrible Herbst. Anything else?
Jan Tomasik for Terrible Host. Nothing further.
Okay, Mr. Odou, what is your procedural question? Go ahead, please.
Your Honor, does the court, and I just can't recall, does the court have a preference for which version of the jury instructions that are preferred? The prior trial, we used the 1986. We had to scramble a little bit to find them. We found them. But perhaps this court has no preference. I just don't remember.
I have whatever the law allows, because as you know, both sets of proposed jury instructions have some issues that have been overturned by applicable case law in different areas. I'm not saying anything specific to any of these areas. So I like joint stipulated ones if you want to know my personal preference, but those don't normally happen, right? I mean, the stock ones. The court doesn't have a preference because realistically, I understand that only one of them were technically approved by certain bodies, but at the same time, there's a custom and practice, and the Supreme Court has supported custom and practice in utilizing something that's been published by a well-organized and knowledgeable body. So I see what each party proposes. I have yet to have anyone object to the concept of using one version versus the other. If you are going to do those in totality, please do it at your meet and confer right before you submit the proposed jury instructions, right? So I know it's coming.
Just a starting point, Your Honor. We appreciate it. Thank you.
Yes, it's realistically it's just what makes sense for your specific case. I mean, they both have issues.
No, Your Honor. Eric Pepperman for plaintiffs. I thank Mr. Odou for raising that with the court, knowing that you have no preference between the different versions and it's up to the parties. That is very helpful information, and we'll be able to, I think, resolve a lot of the jury questions.
I mean, realistically, you all are the ones who are, if you have an issue, are going to raise an objection. So I really find it's the best interest to have the parties resolve what they want for the actual language to be provided, and then have the court make the rulings therein. Like I said, my only caveat is if somebody is going to object in totality to the use of something other than the 86, then I would like that addressed up front, because I wouldn't want people to waste the time to propose a whole bunch of things, right, if that's going to be an issue. So we do that in a nice, organized, two-step process.
Thank you, Your Honor.
That answer your question?
Yes, Your Honor. Joel Odou for Real Water. We appreciate that.
Okay, so here's your question on your jury questionnaires. Nobody requested this, but I am perfectly fine if you want it. And this is more of a Hannah and a Terrible Herbst question. Nobody requested that the red line versions become court exhibits for purposes of the court's rulings here today. Now, I've written on my specific copies, but we could easily print out another copy. Is anyone requesting that they become court's exhibits from today's hearing? If anybody is, you need to let me know. If not, they're not, and I made the rulings on the record.
I have a copy if Your Honor needs one.
No, I appreciate. I just want trying to find if somebody wants it to be court's exhibits. Nobody asked me to, but I'm really just trying to give you the benefit of the doubt in case somebody does, so you don't later on say, "Guess what? We really wanted to." And now it's too late.
Here's on behalf of Hannah.
You do not. Terrible Herbst, are you requesting they become court's exhibits?
We do not, Judge.
Okay, then they're not. Perfect. Okay, well, you got the memo. I told you what's going on with jury services. We walked through all the other things. Last call for anything that can briefly be addressed today. By the way, since I see you on the 28th, I'm inclined to put the OST motion, although it was your colleagues for Real Water, the motion to associate on the 28th, since I'm already seeing you on the 28th, is what I'm inclined to do. Okay. The other thing you're probably going to ask me is you asked me, Mr. Parker, to address what are the actual dates for the motion hearings, because you wanted me to address that. Is that what you were about to say?
Absolutely.
Okay.
You have a
Just
great
making
memory.
sure I circled on everything else, so I circle back to that. Okay. Using the word circle twice in one sentence. Well, it's been a long day. Okay. My inclination is to start you on the 13th, because I do have a trial that's the 11th and 12th in this business court, so it does take preference over motion calendars. Okay. Last week it was stated that you didn't know how many motions because of how many parties, right? And you didn't know how I was going to rule today. So what's going to be the best way to do this is that you all send a joint. Remember I said that the court was going to be fine if there's a particular order that you wanted the court to hear the motions, as long as people timely got them in. If somebody files an OST, you risk the fact that it's not going to get heard. I'm not saying it will or won't. That's not an opinion. I'm just saying feel free to read court's orders, right, and read the rules. And I'll evaluate it if there's some good cause. I mean, who knows? But so if there's an order that the parties prefer, I can hear it in that order. So what I would like to do is give you, and the amount of time, I'd also like to know the estimated time for oral argument. Please be realistic, not, well, we're going to ask for the moon, right, and therefore we can get 1 star, okay? Because we'll try and balance that time. I'm trying to get an idea of how much time you all actually need. I've had a chance to peruse a lot of the filings, okay? But I need it from you all, your ballpark of how much time. So I am anticipating starting the 13th. I can go through, well, it depends on how long you all want to be here. I'm here for the holidays, so, but I'm also cognizant that people might already have prearranged family plans. So we're going to try and get you, taken care of. So how many hours do you need? That's why if you do a joint letter that says, look, here's our motions. Now there's one motion that's currently set, which wasn't supposed to be set in advance, but I have to walk that through for one quick second. I'll ask you your question again, Mr. Kavanaugh. Let me get the generals and then I'll ask specifics. Answer specifics, please. Okay, so from the general concept, it was good and we were going to start, I said around the 12th, but I have a trial 11th. It may be done on the 12th. I possibly could start you the afternoon of the 12th, but I think you'd prefer me to say for sure on the 13th rather than say possibly in the afternoon of the 12th, and then you block out time, potential people fly in, and then my trial continues. So that's why I'm more confident to say the 13th. I need to know how many hours total you need, which is how many days we're going to be doing it. Now, I'm still going to have some motion calendar, so I might just have to figure it out, right? But you all have a better idea now that you've filed your motions, the totality of the time you need. Okay, so we can just, it's really, what I've got planned is after my morning calendar, it's you all starting on the 13th till we get through all the motions. That's not to say hours and hours of oral argument on each motion. That's just to say I've blocked out sufficient time to get you taken care of. How much time you want to argue is balanced. How much time you want to go away for your holiday plans, right? Or maybe you don't have holiday plans because you're starting trial a few weeks after the holidays. Whatever. I'm just trying. I can balance some things in there depending on what you all's needs are. Unless you could tell me right now how many total hours you think you need, and I should block them out now, but I think you probably want to talk among yourselves, revisit after things from early rulings earlier today, and then if I give you a deadline in which to get me said letter with the order that you want, or if you can't agree on an order, then just give me, I mean, everyone always agrees on an order. I don't really need a plan B, right? And if there's a couple ones, then just say, suggested this or this, right? And get you all taken care of. Does that answer your question, or do you want something more specific, Mr. Parker, on behalf of plaintiffs?
No, Your Honor, thank you. Teddy Parker again on behalf of plaintiffs. I appreciate that, Your Honor. We'll be here bright-eyed and bushy-tailed on December 13th to argue the motions. I will just give the court just a little background. From July 24th until September 5th, we argued pretrial motions in the other case, virtually every day.
Mondays and Fridays, I thought.
No, just virtually every day. We only had a few days that were dark, and most days started around 10 o'clock, 10:30 until just 4 or 5. So.
You don't think that there's enough time blocked out? Is that where you're heading? Because if you are, tell me now and we'll find some more time. I mean.
I just don't know how we're going to be able to do it, Your Honor, but so we have motions on this stack that are on this grouping of pretrial motions that are different than the others that may cut out some claims, but I just wanted to let the court know we took over a month virtually of time arguing motions the last time.
Well, realistically, like I said, the 13th, we have the 13th, part of the, most of the, okay, hold on real quick. Yikes. Currently, we're trying to keep these as clear. Now remember, today's only November 13th, so some things with the 28 days, some things may pop on the calendar, right? And some continuations. But
Your Honor, if I can add, Eric Pepperman for plaintiffs, the motions in limine are not due until Wednesday. And so we will be filing the motions in limine Wednesday and be able to have a better idea once we review those motions on trying to determine some time estimates. So maybe if we can address it and submit something prior to the 28th, the hearing on the 28th, and then
that's fine, as long as you all have enough time to get where you need to be, because please don't ask this court to read thousands of pages within a few days, and that's not an entry, you know what I mean? We need things in ordinary course of 7 days, so now I'm fine with that. Right now, I was just trying to give you a heads up, I did not set a trial after the 12th, okay? So the 11th and 12th is my last trial, figuring that I would have some things on motion calendars and those last-minute emergencies that always pop up, particularly at the end of the year. So realistically, we have calendars of less than, now remember today's the 13th, so certain things can still get placed on it. We have calendars of less than 10 items per day starting on the 13th at the end of the year, with the intention of trying to give you as much time as I thought it would be necessary for these matters to be heard fully and fairly, okay? So earlier rather than later, right, because of your timing when you have to get everything else done, right? Exhibits, pretrial memos, all that kind of good stuff, okay? There is one motion in limine. Since I clicked out of, I have to now go back into, is it set the 5th? There's one set the 5th, which was going to get moved to the following week. Was there a reason that needed to be on the 5th? I know I was asked the one specific question, if somebody filed it early, could it get set earlier? But, one second. Your case takes forever to open up. Defendant ETT1, Terrible Herbst, motion eliminated to exclude evidence of references to the stipulation of admission. So, and one joinder there too. That is currently, because that did not have the date that I said to put on the caption, the clerk's office set it for the 5th. I really was intending that pretty much, because I was asked before that people filed it, sooner would they get the front end of the, starting the 12th or 13th, and I remember saying, unless the parties just, agree that there's a different order, because I didn't want people filing at the end, right? And the people who kind of filed earlier. So I was intending them to be one of the first ones to hear on the 13th. To the extent that there is still, well, I have to go through the 2.47 in my rulings earlier today, so to see what's left of that one. That was planning on going on to the 13th, taking it off the 5th. Was that your question, Mr. Kavanaugh, or was there a different question you had?
Your Honor, I was just wondering, wouldn't it be simpler just to have the matters be heard in the order, scheduled to be heard in the order they're filed, and then the parties agree to ask the court to move them up or back in the schedule? The court could do that. Having us manage the court's calendar, I think it's kind of a...
You might be misunderstanding what the court's saying. You all filed a whole bunch of motions already, right?
Going to file about 100 more.
Right. Okay. So take it. You file 100 on a particular day. The clerk's office does up to 50 of them on one particular day. Does anyone think that you're going to get through 50 motions in a day?
No, Your
I mean, I can. I give you inclinations and nobody wants to argue, but realistically, you're not. Okay. So what we've done successfully in the past, not done the Sun CD cases you've been involved in, is that people file all their motions, but then they provide to the court. We would like, you know what I mean? You have your high priority ones. Oftentimes it's the summary judgments, right? That you want to, that even if somebody files their motions eliminating, their summary judgments already been filed, right? But there's a whole bunch of them. So you might have some that you know are coordinated with each other. So you want them heard, grouped together, right? Because they may be on a particular topic. Court's fine doing that. Okay. If not, what's going to happen is, and it didn't happen already, right now the clerk's office hasn't scheduled anything, which I have to find out. And then we had asked to put the caption, right? To put like set by the court on the 12th. I haven't gone back to every single one to see if you all have done that or not, but now it'll be the 13th. So if you want it that way, right, then what you're risking is whoever's filing at 12:01, right, the clerk's office clicks it in, you might get towards the top of that pile, but you may be more interested in somebody else's motion to be heard, right, that might make yours moot or not. So I give the parties the opportunity that you can do, they all get filed, they have to be all filed on time, but then basically it's a letter to the court. Your Honor, you know, this is the order we'd prefer to have these motions heard, the parties have meet and conferred. If you want that, I'm okay doing it. If you don't, then I pick the order I hear them. Either's fine, just that, I mean, that's really, most people like that accommodation because you can prioritize or you can group, you know what I mean? Different things. And that way you deal with it as you want things to be heard. But if you don't, I'll pick it. That's fine. Okay, so bottom line is, you asked after the 28th, what date do you want to do the letter? And if I don't get a letter, I'll pick the order.
Sounds great, John.
What date? Because you said for when motions eliminate. What date should I say that I need the letter by so we can coordinate? Because I'm also going to tell you the preference of this court. We have found it so much easier when people give us. I'm not requiring jump drives because I fully realize the EDCR tells me, right, paper copies. So you can pepper me with paper copies and binders, but realize it's a lot more convenient for you. It saves money if you give a jump drive, right, with your motion opposition reply, right, nicely organized in that because then you just can download it, and since you're dropping something off anyway, you know, do something that's a couple inches and light. But I'm not precluding anybody from giving me hard copies. I'm telling you it's more convenient to give a jump drive. Does anyone think it's less costly to print out binders versus giving a jump drive, which is a few bucks these days? And that way, the team members, you file it and then you pop it on a jump drive, right? And you can put a whole bunch of things on that. But
Your Honor, Joel Odou for Real Water, clarification on the jump drive. So the jump drive would have, as an example, motion, opposition, reply, like in a folder, or what's? Yeah. Okay.
So you could put, yes, motion, opposition, reply, folder. Then another one could be your 10 motions eliminate, motions, oppositions, replies, right? And other folders. I would not, now those folders, please title them. I say that because someone didn't. It was lots of fun trying to find it, but you know what I mean? It's what you do anyway from a nice organized manner, okay? Motion for partial summary judgment on X, right? Motion eliminate on X, opposition, right? Reply. It's just a cleaner, quicker, easier way. It's not required, but most people have found it more helpful. Does anyone think it's not more helpful and quicker and easier? If you don't think it's a good idea, let me know. I mean, I'm not forcing it.
No, Your Honor, that's preferable for plaintiffs. Thank you.
Either that or you send it to us. I review everything. Yes, I put my post-its and stuff and do all sorts of notes. Then you come back and you pick them up later, right? So you've got a couple of courier costs, you've got the printing cost, you've got the binder cost, you've got the time cost, you've got the paper cut cost. All that can be saved with a few bucks for a jump drive these days. Now, we do expect that you're making sure the jump drive is clear before you give it to us, right? Meaning it doesn't have viruses and it doesn't have things that I'm not supposed to see. But okay, anything else? Because folks, I said 2:15 and I'm really supposed to have been somewhere else and on a meeting. We're good?
Yes, yes, Your Honor. Thank you
Okay,
so
so who's
much.
writing my excusal note for the Judicial Council meeting that I missed on legislative aspects? I'm just kidding.
Mr. Parker, I think will have.
Who's writing that one? I'm just kidding. Okay, thank you so very much.
Thank you, Your Honor.
Have a good one.
Have a great
Okay.
day.